together to create what didn't exist 10 years ago, and that is cyber liability. And then Alex will touch on some of that and also touch on the insurance piece of it and the market and how the market and the insurance world has responded to these new risks that risk managers see. Cognizant that there are quite a few folks in the education world on the line, so we'll make sure we guide our comments and some of our examples in that direction. But think about it this way. For years, when we went to stores, we gave credit card information. We went to schools and signed up our kids or signed up ourselves for colleges. They would ask you data about yourself. You just gave it to them all through the 80s, all through the 90s, no big deal. You're giving out information left and right. I mean, even now, I have young kids, and the local soccer leagues, on their forums that are 20 years old are asking me for their Social Security numbers. Not sure why they need them, but they ask for them. But that kind of environment is what the United States has been for years and years and years. And companies and organizations and schools have taken that data, partly because it's helpful for what they needed, and partly because they stored it in thinking that they could possibly down the road use it for some kind of mailings or marketing, etc. So it wasn't hard to collect it. It wasn't hard to store it. Why not, right? So that's what happened. What then happened was a whole bunch of laws that didn't exist before started to be brought into place, most of them in around 2003 or 4 or since, a few before. But those laws created a whole bunch of different legal obligations, and they made obligations about the storage of data that just didn't exist before. So now entities like universities and schools and retail and everybody else and hospitals that have been gathering this data literally for decades, all of a sudden it's much, much more important now because there are legal duties that are attached to it and can cost significant 6- and 7-figure dollars on managing incidents that occur as a result of compromises to that data. So let's take a look at the next slide, and let's look at the kind of data we're talking about. Personally identifiable information is, as you'd expect, right? My name, my Social Security number, some kind of government-issued number, maybe my bank account. This is driven across the country by 46 different states, and again, we'll get into some of the specific laws. The point two we have here is the broader view. Unfortunately, for everybody on this line, some of the laws in California in particular are now broadening. They're calling my email address, possibly with a password, alone enough to be considered personally identifiable information, or a security question and answer. So it's getting broader, and this definition of PII isn't static. It changes all the time, even to the point where common law courts, just a regular judge in a courtroom somewhere, defines California had happened and in Massachusetts it happened that zip codes with your name are now personally identifiable information. And some of it is on the edge of absurd, frankly, because zip code in your name is on every letter that comes to your house, but just, and every letter that comes to one of your students and every letter that comes to your business. So think about how broad that really is. Protected healthcare information. Everybody on the line has heard of HIPAA at some level or another. We've all signed the releases that our doctors, etc. PHI. That triggers HIPAA high-tech obligations. Payment card industry, and again, we'll talk a little bit about this, but that's the whole world of debit cards and credit cards, and that's a separate contractual, not statutory and not per se legal regulatory regime, but it is a contractual regime that in some respects is just as onerous or more onerous than some of the laws that are out there. Trade secrets and other IP, and universities in particular have a ton of trade secret information, a ton of research that goes on. That kind of risk is out there as well, and I touched on the zip code, so we'll just jump to the next slide. Right, so what's a data breach anyway? Why are we talking about it? The concept of a data breach is this. You gather, or your clients gather, this data, all the data we're sort of just running through here, and they save it, and they save it some more, and they save it some more. And these laws now have come out and said that if you have that data compromised, and that's a vague term, compromised, that can mean that you have lost the data, that can mean that people looked at the data when they shouldn't have, think in a hospital system. That means that you have granted unauthorized access to someone, maybe a hacker gets into your system and plays around in a database Maybe there's proof that they took the data out. That's one thing. But sometimes, in particular under HIPAA, if a bad guy gets into your system and gets into a database, the presumption is that they got to that data. Whether or not you prove that it never left the building or not doesn't necessarily save you from some of the obligations that arise. These charts just give you a sense of the growth of incidents that are happening. On the right, incidents by breach type. These are statistics. I think these are Planomon statistics, which is one of the bigger organizations that gather this information. I can tell you this. I break it down a little bit differently. I break it down 3 ways. About a third of the data breaches that we see, and I have an office of 8 lawyers doing nothing but handle data breaches every day, all day. So that's a lot of work. We see about a third of the breaches caused by what I'll call bad guys, malicious actors. And there's 2 kinds of bad guys, right? There's the dumb bad guy who throws a brick through your window on a Sunday and steals 5 laptops. And then there's the smart bad guy who attacks your system with a virus and hacks inside. So either way, you've got a problem because they take data in some fashion. So that's about a third of the data breaches that we see. Another third is vendors. I mean, I can't imagine there's a university on earth that does everything in-house. You guys use vendors to do all kinds of things, from payroll to management of different systems to IT itself. A lot of different vendors touch data that you gather. And vendors mess up. You can have the best IT and the best policies and procedures, and when you have vendors in the loop, and they call that the supply chain, you have more risk because you really don't have any sense of how good your vendor is. And if you do, you don't even know if they're using vendors to do some of the things that they then outsource. So vendors are about another third. And the other third is in-house. People make mistakes. Employees lose things. Employees look at things they shouldn't look at. They steal once in a while. And so those are sort of the breakdown of where we see most of our breaches. Next slide, please. So let's talk about some of the specific laws that we have to deal with. And I'm not going to bore you, and I will not read to you. So just take a look at this one. State regulations. 46 states plus have different laws. Among other things not being done by the federal government is this. There have been talk of a national law to organize all of this, but the reality is there just isn't one. And the variety of laws out there define breach differently. They define personally identifiable information differently. They have different time frames by which you must send notice. And let me spend a minute on that, and Alex will talk a little bit about this too. But when you actually have a breach, and a lawyer like one of my team tells you, based on the information available, that you have in fact violated X statute, you then have to do things like this. You have to send letters that you get. All of us have gotten them in the mail. Your data may have been compromised, and it gives you some information. Maybe it gives you an 800 number to call. Maybe it offers you credit monitoring. But you don't get those letters these days because people are thoughtful and nice. You get them because there's a law here, the state laws, that demand that they be sent. And if you don't send them as an organization who's experienced a breach, you run the risk of being pursued pretty heavily by either attorney generals or people like the Office of Civil Rights in the federal government or plaintiffs' counsel. If you actually do what you're supposed to do and comply, you still run some of those risks, but not as significantly. But the point being, these laws right here that we're looking at, these are the reasons that you have much more exposure to risk than you used to. You can go one more forward. That's fine.
Yeah, and just to add to it, on the state end, one thing that's really important to know is that these state laws, they're written with a basis of the domicile of the person affected, so it's essentially the residency. So you might be a school or a higher education institution in one state, and you may have an assumption that you only have to apply the state notice law for where your school is based or where the incident occurred. But the reality is it has to be based off of the residency of the person affected. So clearly in the higher ed world, you could imagine easily how you could have representation from all 50 states and around the globe. You may even have, a K through 12 school where clearly you think, well, everyone's from the same city or the same county or state, but you may have old data that's part of your breach, and people have moved since then, and you have to go with the most current address, not necessarily the address that you had on file from a student from 10, 15 years ago. So immediately when you think about these 46 laws here that John's talking about, this is a very easy way to raise your liability stakes by not complying with a particular attorney general's requirements. And as we all know, AGs like to grow up to be senators and governors, and what that means is they love to take advantage of organizations that don't follow their laws so as to get that political drive, if you will. So this is one area where John and his team really stand up to show the expertise you really need to have at this point in time.
And that's a great point, Alex. The fact that universities and schools almost certainly have kids in them who end up all over the country. I mean, I went to Arizona State Law School. I live in Philadelphia. I mean, that's just a typical example, right? So, you know, times that by thousands. The other thing is, you know, and this sort of harkens back to the earlier days of e-discovery. I challenge anybody on the phone to look at their organization and tell me they know what data their organization has, where it is, how long they keep it, and could identify it all. The fact of the matter is, unless you're really disciplined and funded, it's very difficult to know all the data that your organization has, how long you've had it, where it resides. So this risk is pretty systemic, and it's across the board. So those are all very good points, Alex. Next slide, please. Just a real quick sampling of some of the states that are out there. The second bullet point here shows you in mass that not only do you have, you know, duties that apply if you compromise data from somebody who lives in Massachusetts, but they actually require that you have a written information security program pursuant to their state law, even if you're a university that sits in Georgia or Pennsylvania or California. So, you know, you can argue jurisdiction till the cows come home, but that's the law, and you will run afoul of it if you have a breach and you don't have that proactive plan in place. And the last point here makes the point that Alex just talked about. This law in Massachusetts, and they all do, they apply to people all over the country, not just in Massachusetts. So let's just jump to the next slide. As an example, here's a California statute talking about if you're a certain type of healthcare healthcare company, i.e. potentially a California university with a healthcare department. You know, everybody's got the clinic on campus, and more than a few universities in higher education are affiliated with teaching hospitals for medical schools. 5 days from the notice. From a practical matter, that's on the edge of impossible, by the way. So, you know, the statutes are there for sure, and Alex is spot on when he talks about AGs being aggressive. For one, some of the AGs are self-funded, so if they're not finding people, they can't keep their people employed. The Office of Civil Rights enforces HIPAA high-tech for the feds, and that is self-funded. So you've got a whole bunch of federal prosecutors. By the way, they're hiring, and they only can pay themselves in the end unless they find entities that have had HIPAA high-tech breaches. Go ahead and jump to the next slide, please. So here's some of the federal laws, and again, we don't have time to go through this. There are seminars that last 3 days on the topics Alex and I are covering in a little over an hour here. The first one is HIPAA high-tech. Most of the people on the firm have on the phone have heard of that. It is a very low threshold. In the world of HIPAA, if it applies to you as a covered entity, if it applies to you as a company or an entity that does business with a covered entity, you have unbelievably low thresholds. For instance, if a hacker gets into your system and gets arguably unauthorized access to the data, even if you think they never took it out and they never printed it, arguably you still have a duty under HIPAA to send those notices. When you send notices to HIPAA under a HIPAA law, on top of everything else, you actually have to tell the feds. The feds then take the notice that you give them and put it on their website. So it's not really all that helpful. Some of these other things we won't really get into any great detail. President Obama issued the executive order recently in the last 12 months talking about, you know, guidelines for more and more regulations around cyber liability, et cetera. You've got laws here that apply to banking, apply to publicly held companies, you know, all kinds of different things. If you take credit cards and debit cards, and who doesn't, right, for all kinds of different reasons, then you've got the Fair and Accurate Credit Transactions Report. That's why, by the way, when you get your receipts at the, at a store, there's no more than 4 digits and a bunch of X's, because that's a part of that law. There's just a lot of different variables, and this is not an exhaustive list. Next slide. Yet more proposed legislation, right? So there have been something now in excess of 30 different laws proposed to sort of deal with all of this. Some of them are practical, some of them are impractical. I mean, some of them carry things like giving the customer or the student access to their data so that they can tell you when it's wrong and correct it. In theory, that sounds good. It's absurdly difficult to do in the real world, and it would be so prohibitively expensive as to potentially close down companies. So it's not all that realistic when you see some legislation floated around, but you can expect more, not less, complexity as time goes on. And the plaintiffs' bar is watching all this and coming up with different theories to pursue you when they want to. Next slide. Let's talk a little bit about PCI. This is the payment card industry. So think Amex, think Discover, think MasterCard and Visa. These guys have gotten together and basically created, in my opinion, an oligopoly. There's 4 or 5 brands, and they control the whole world of credit cards. If you have a data breach that compromises credit cards, among other things, you have to tell the bank that you use to clear all your credit cards, and then the bank tells the PCI world, which is this like murky world created by card brands, and all of a sudden you're told you must hire a company to come in and do a forensic audit on your systems to figure out what your systems really look like and what happened here. You will pay for those auditors, and they will report to PCI, not you. So that can be a very, very difficult thing to manage, when on top of that you're also managing the PII analysis and determining whether or not you have to do state law notices or other type of notices. Now at a university, and Alex and I were preparing for this conversation we're having with you over the last several days, and unfortunately for those on the phone in higher ed, you guys have it all. You have personal information that's Social Security numbers and driver's license. You have healthcare information. You have PCI data. So in terms of a treasure trove for the bad guys, the folks on this call listening, both themselves and their clients, have that data. So it is a very, very difficult thing to deal with. The industry, meaning the insurance industry, is evolving toward covering those investigations and the fines and penalties that result, but that's not always the case. So you'll want to be careful there. Next slide. This is more of the same. You're going to get these slides, folks, and not for a second did we think we would be able to go through every one of them, because we've got quite a deck to go through, but I wanted you to have some of this stuff so you can see what's what. Nevada, for example, has taken the PCI standards of security and made them the state law. So you've got interplay between this contractual regime and state laws as well. Next slide. International laws. It's never simple, right? You've got state laws, you've got federal laws, and yes, you have international laws. You've got the EU, all kinds of stuff going on in the EU. In fact, I was over there presenting not that long ago, and the proposed EU new law on notice requires notice 72 hours after you determine that there's been an event. Now, I think Alex would agree with me that if 5 days is ridiculous, 72 hours is absurd. And yet, they could come after you, even over here in the U.S., if you violate that and you've got people from the EU community in your student database or employee database who get compromised. So it is a bit silly, but these are the laws that are out there. And remember, legislators are passing laws. The people who enforce them are either plaintiff's attorneys or AG types and regulators. They're a whole different breed from each other. So legislators like to get in the paper, they like to pass flashy laws and get reelected. The guys enforcing them come along and enforce them either softly or with a hammer, and you just don't know which. And another thing I will tell you, on the 46 state laws we talked about earlier, about a third of them require not just notice to the individual, me, let's say John Mullen in Pennsylvania, but also notice to the Attorney General of my state, saying, hey, this happened and it involved 2,000 people from your state. Some states get those letters and just file them. Other states, among them Indiana, Vermont, Washington, California, Massachusetts, they follow up. You get attorney generals calling us as the lawyers, you get letters, you get investigations, you get interviews. I mean, that can really, run the cost up quite a bit. Next slide. More international laws. The short version in Canada is this. The two that you see at the bottom, Alberta and Ontario, depending on how you qualify, have mandatory or semi-mandatory laws. But there's a point here that I'm going to add next time around. There are guidelines in Canada that basically strongly suggest that anybody who's a Canadian citizen whose data is compromised should, it's underlined should, receive notice. Not must, but again, the question becomes, do you really want to run afoul of these kind of recommendations from federal governments? Next slide. Let's talk a little bit about a couple quick case studies. This is a case we had, we had a state university system that shared data with a state college system, and one of them had a breach, and we were called by the other. So the university had the breach, the colleges didn't. And they called us and they said, hey, this is going on, and we don't think we're involved, but we did share a vendor. Fast forward, 450,000 letters later, between the two of them, it was an expensive proposition. They did, in fact, have their data compromised, and because they shared it between the two, it got more and more complicated in terms of how you get the forensics in there, and who has the privileges to get into the data and do the forensic work, and what about law enforcement coming in. And ultimately, a massive call center was set up, and credit monitoring was offered to going on 500,000 people. Credit monitoring, depending on how it plays out, at the low end is going to cost you nearly $20 a head per year. So you can start to do the math and get a sense of how expensive this can be. And call centers aren't free, and frequently asked questions that need to be developed aren't free, and the letters don't get mailed for nothing. So you get a sense of where some of these costs come from. And on top of that, forensics and lawyers are something you'll run into. So that was just one example of one of many. I mean, I was telling Alex, we literally have represented Big Ten, Pac-10, all the big conferences and everybody in between, all kinds of state systems, citywide systems. So there's a lot of data in higher ed, and unfortunately, you guys aren't always funded as well as the Fortune 1000 companies to protect it. Next slide. There you go. So the hospital employee steals information. The same thing has happened to us in the college context. You've got an employee who has legitimate access to data, and they steal and actually create credit cards and fake fraud. When we first got that case, we thought we're going to have a big problem here. This person's had access to 70,000 records. Fortunately, when we got the forensic guys in there, they were able to distinguish between the criminal activity, i.e. places this employee went where she shouldn't have, versus places where she went legitimately and seemed to have a legal basis to be there. And the good news, as you see on the slide, is in the end, only 11 people out of 70,000 needed to get notice. So there can be good news when you get these breaches, because if you get the right team in there ahead of time and you've got the insurance in place, you can manage it and come away with a good result like this. And you can imagine the cost savings of dealing with 70,000 folks versus 11.
And John brings up a good point here, because one of the things that I'm sure John has seen in his years, and I've certainly seen over mine, you cannot assume you know the facts. You can't jump to conclusions. Going through a proper investigation is essential these days when you have an incident surface. I have seen more than enough occasion where a client has assumed that they thought so many people were affected, and through an investigation, you actually in many ways can prove a lower number, like this example, or even prove a non-event, meaning no breach has occurred. Now, yes, in some instances we've seen where you assumed on the lower end and the investigation proved you had more, but at the end of the day, that still serves you well because you now have a more accurate, realistic view of what's happened, and regulators like that, and quite honestly, from a reputational side, that benefits you as well. So definitely take advantage of an investigation phase as you're going through any potential incident, because it certainly can give you a positive outcome.
Yeah, I mean, that couldn't be more correct. The fact of the matter is that people, the next call I get, and we handle maybe 4 breaches, net new breaches every single week all year long, and that number keeps rising. But the next call I get where the person on the other end tells me all the facts and gets them right will be the first one. Because people really try their best to give you the right data, and they believe their IT folks, but you know, the example is this. I have a great general practitioner. I've had him for 20 years. He's a great guy. If I ever have to have shoulder surgery, that guy's not going anywhere near my shoulder with a blade because he doesn't do shoulder surgery. You can have great IT. They don't do data breaches every day. You need experts in there who do this thing right. For example, we had a case this week, and it was a university. We didn't have time to put it into a case study. CryptoLock is a thing that's out there that's getting into systems and encrypting systems automatically from the web, right? And you get a note that says, put $1,000 on PayPal or we're going to burn your system down. Then people pay it. So we had a university who paid the $1,000, called us. They had the right coverage. We went in, got forensics in there. They have 100 servers. And they were telling us they believed that they were going to have to do notice for in the neighborhood of 300,000 records. We had forensics in there over a weekend, and in 4 days, now this doesn't always happen this quickly, in 4 days the forensic team was able to say, yep, they got hacked, yep, they got in the system, and when they got into this server, this is the one they came in, they tried really hard for 3 days to get out into those other servers, and they didn't get there. 0 PII, no notice. So what would have been a $600,000, $700,000, $800,000 event turned into a de minimis event because they were smart enough to get the right team in there early and did that research. Doesn't always happen that well, doesn't always happen that positively, but it happened this week. Next slide. Right, so, you know, and we can do the bottom part of this slide too. You do spend more money, this has statistically been shown by Ponemon, you do spend more money if you move quickly, but if you don't move quickly, the lawsuits, the reputational harm, and the regulatory investigations can be significant. Here's one thing I will tell you, and I think Alex will agree. You don't want to move so quickly that you pull the trigger on a notice that you just didn't have to do. And that goes back to my comments earlier. Those guys were starting the process of noticing 300,000 people, and because we calmed them down, they ended up doing none. Next slide. The kinds of lawsuits you can face. And mind you, think about it this way. There's really two big exposures here. One is, and this is what we've been focused on so far, is the first party. That's crisis management. That's hiring John, the lawyer. That's getting the investigator in. That's determining the facts. That's hiring folks who do, you know, the mailing notices, making sure they look professional and they go to the right addresses, hiring the people who do the credit monitoring. All of that is what we call first party. So that's all happening before there's any lawsuit. And frankly, from that can happen investigations by attorneys general, OCR, and all of that happens before you even get sued. Here, you can get sued, right? So you can have the individual plaintiffs coming after you. Much, much worse case, you can have class action coming after you if your numbers are big enough. You can have the government come after you. Multiple attorney generals have brought lawsuits against multiple institutions. Massachusetts is not bashful, neither is Connecticut, among others. And they can also enforce HIPAA high-tech. So you've got federal laws that are enforceable by state agents. Banks can come after you if you cause banks to have to reissue thousands of credit cards. That doesn't happen for free. If you end up having some kind of services you provide to another university or another higher ed, maybe you share IT systems like the example I gave you, and you have a breach and they spend $1 million, they can turn around and subrogate against you and hand you the bill. PCI can come in and fine you. There's a lot of different lawsuits and actions that can happen. Next slide. So, and this just makes one quick example of how expensive a class action can be. And by the way, there have been class actions against hospices, for God's sake. So it's not like the fact that you might be an educational institution, you're going to get a pass by either the government regulators or by the plaintiff's bar. They have no heart, guys. So, you know, they don't care that you're in the business of higher ed. But you can get pulled into a class action case. You've got multi-district litigation. That can be 6 months of just fighting about where you're going to start. You've got class certification discovery. I won't read them all. E-discovery, experts, lawyers, spoliation. It gets very, very expensive. In fact, you can pretty much bank on the fact if you're in a class action, you will spend millions. And that's to win. This slide, and I won't go into it in any great detail, the point of this slide is very simple. 6 years ago, I didn't have these cases to put here because the defense always won and they couldn't really state damages. What are damages? When you fear future identity theft. That's just not enough. The courts were throwing them out. you have a list of cases here where a variety of federal courts, which is where class actions generally live, are starting to give the plaintiff's bar little cracks where they're able to get in there and get past motions for summary judgment, motions to dismiss. And every time you fail to get out of a case, the risk goes up, the cost goes up, and the payoff to the plaintiff's bar goes up. Next slide. Preparation, I mean, I guess you're getting the point now. Although the cost of a specific data breach can go down or up over the course of the years depending on the statistics, if you prepare, you will manage them more effectively. And let's talk a little bit about some of the preparation you can do. Go ahead, next slide. You have to understand what the risks are, and this goes back to some of my comments earlier. You have to understand where your data is, where you collect, store the data. Do you outsource it? Do you share it? And if you don't understand these questions, and again, this will be made available to you, so I don't expect anybody to memorize this stuff, this is the kind of analysis you have to go through. Next slide. There are companies out there that will do assessments for you, and they will tell you with their report card, you're good in these areas, you're okay in these areas, and you're lousy in these areas. Go get one of those companies. They are not that expensive. I mean, there's a company, Net Diligence, among others, that does this stuff, and everybody on the phone's worked with them. So there's a lot of companies who do it, but there's something that you should do. It will give you the report card you need to actually get better deals when you're buying insurance and have better security. These are some other questions. Do you use encryption? How long do you maintain this data? All of this comes into play, and when you have a data breach, the regulators come in and they ask you all this stuff anyway. So they don't just come in and ask you, hey, what happened here? They come in and they say, what happened here? And show me what you did for the last 5 years to show that you were taking data security seriously. So if you don't have these questions memorialized and documented in your entities, you will run the risk of bigger fines and bigger problems. Again, this is the kind of stuff that we see in all these different seminars that we go to. Bring your own device. People are letting people who work for them get their iPhones, get their Androids, get their BlackBerries, and all of a sudden those people, especially the higher ups in the institutions, have access to potentially massive amounts of data. If those devices are lost or stolen and not reported to you, then you've got high-level people with admin level access getting into all kinds of data. When I was in school, I worked in the financial aid office at Penn State. I can only imagine the data that I had available to me back then, right? I was a teenager working in an office with all kinds of data about 50, 100,000 students, and I was able to get to that. If in those days, if we had mobile devices, I would have had access to that stuff from an iPhone. So, you have to start to think about how that kind of technology is impacting the risk. And all of these risks happen, and all of these cases happen literally every day. Next slide. What can you do to really start to get rid of some of this risk, or at least appreciate the risk you have? You can create things like, and we have a slide following this called incident response plans, right? So if you said to me, John, gun to your head, what do we need to do here? I'd say assess your risk. I'd say create an incident response plan once you know what your risk is, i.e. what is it you're going to do when you have that data event? Who's in charge? Who's not? Who's the decision maker? Who's not? Who are you going to call? A little bit of a Ghostbuster reference there. I mean, literally, what lawyer are you going to call? What broker are you going to call? What carrier are you going to call? And how are you going to deal with this? And then you do tabletop exercises, which test the thing that you create. So you need to have a plan in place. And frankly, you need to have insurance in place. And I would say this if I were speaking to you without any insurance people on the phone. I have it at my firm, and when I got here 6 years ago, we didn't have it, and within a week, I made them buy it. Because I realized that when I get the calls, and like I said, we get 4 or 5 a week, I'd say 1 of every 4 calls me without insurance. They have a much bigger problem than the people who call me with insurance. The people with insurance still have a big problem, but not nearly as big as those calling me without, because the government, the plaintiff's bar, the regulators, and the law don't care where the money comes from. They just want it done. Next slide. These are the incident response plans. Again, I'm going to hand off to Alex in a minute or two, but these are the plans, and this is some of the things you should be thinking about when you create these plans. think about it this way. If you don't plan ahead of time, and you're just not ready when it happens, it's only going to increase the chaos, and you're going to have turf battles. You know, risk manager creates the plan. They never ask general counsel's office if they're okay with the plan. Risk manager thinks they've got a good plan. The event occurs. General counsel's office rolls in, pushes risk manager off the issue, and takes over with no clue how to manage it because they were never involved in the first place. I see that happen all the time. So when you're making an incident response plan, you've got to get all the different parts of your organization to buy in with the plan way before anything actually happens. I'm going to pass off to Alex now, and I think he's okay with me reserving the right to interrupt him as well, which I think I will probably have to do. But go ahead, Alex.
Absolutely, John. No worries.
We can also take any Q&As from anybody that, you know, has for John. I see one already. What does California and Massachusetts mean for zip codes?
That means that in those states, although they have a statute that doesn't define name and zip code as personally identifiable information, under their statute, so for a long time, their statute read the way it was, right? In both of those states, in related litigation, judges have defined zip codes to be personally identifiable information. So it's now created sort of a disparity between the statutory law and the common law in those states, creating arguably a duty to do notice in those states, even if you just lost a list of names and addresses.
Any other questions from anyone before we move on to Alex's? Okay. All right, Alex.
All right, great. Hey, if we could just advance and just see, that'd be great. And one more time. And just obviously, John being counsel, of course, but since I'm not, it's just obviously fair disclosure, I'm not an attorney, so my materials, obviously information purposes only. So certainly can consult with your own counsel for any decisions regarding your privacy matters. Next slide, please. You can go to the next slide. And one more time. So right off the bat, one of the things that I'm often approached by clients is, what is a data breach? Because here's what we're talking about. We're talking about what data breach impacts have on organizations, on your institutions. And at the end of the day, the definition of a data breach, as John alluded earlier, it's going to vary from jurisdiction to jurisdiction. There is no one-size-fits-all definition. And in fact, I would even define a data breach even outside of what the statutes define, because we can't just rely on what the statutes tell us is a data breach, because there could be a lot of reputational harm factors that may come to your organization that are not really addressed completely by state laws or federal laws. And the way I view it is, it's the release or disclosure of that information that can cause inconvenience or harm to a person or to an entity, a corporate entity. And the best example I can give you is email addresses. And I know, as John mentioned, you know, California just recently amended their law to include login credentials, which often is email address and password. Aside from that, most states don't define email addresses as sensitive information. But if a hacker got into your databases and stole the entire student body email address, a database, could they take that a repository of email addresses and commit spear phishing attacks and cause students to lose login information in their bank accounts, or login information to their school accounts where other identifying information is located? That could, and could that cause inconvenience or harm to the person? The answer is yes. So don't just view a data breach as to what the statutes tell you, but truly from the reputational perspective, can it cause harm or inconvenience to that person or to your institution? Next slide. The kinds of data breaches that are often out there, and I'll definitely concur with John's analysis of, you know, a third attributed to third party, a third to malicious, a third to employees or insiders. But even amongst that statistical base, there's different types of causes on how these events occur. The most common that we often have seen at Beazley is improper disposal of data. And if you'll notice, I focused first on paper. At Beazley last year, we serviced, I think, about 320 or so data breaches. 18%, almost 1 in 5 of them were paper-based. So as much as you put all your initiatives on your electronic data and having the best talent of IS and IT professionals, you cannot lose sight of your paper records. And having protection around those are just as important as the electronic information. Some of the examples we've seen over the years, unshredded documents, not having shredder bins or shredding practices easily accessible for the workforce, for your employees. That often leads to employees throwing very sensitive information in the round file next to their desk. And why is that the case? Well, we're all human, and unfortunately we tend to be a little lazy, and nobody wants to get up and go to the other side of the floor to go where the shredder is or the shredder bin. And the problem we have here is a lot of these unshredded documents wind up in the dumpster behind your offices, and in the middle of the night, guess who's going through the dumpsters? And the answer is not the criminals. There have been many examples where regulators like attorneys general will actually send their staff looking for this information. And this goes back to the point I said earlier where attorneys general, they have political drives, and anything to get in front of a microphone is to their benefit. And unfortunately, there's been enough examples of AGs, particularly in Connecticut, Massachusetts, and Texas, where they've actually done this. And so you want to be mindful of making sure that those documents are shredded appropriately. We've also seen cases where file cabinets are disposed of or donated to charity because you may have consolidation of offices or facility shutdowns. And lo and behold, no one has bothered to check the contents of those file cabinets for paper records. And what happens? The acquirer or where it's disposed of, someone opens those drawers and lo and behold, they find student records or they find financial aid documents and so on. So once again, be mindful of any kind of initiative you have that is like some kind of M&A or acquisition or shutdown. Include an element of privacy as part of that initiative to make sure the so-called every drawer, every closet, every file cabinet has been checked before the last person walks out and turns off the lights.
Hey, Alex, let me just add to that. There's one pretty well-known breach that happened where somebody took a Redwell home on a subway and it had 190 medical records in it. That was never seen again, probably burned at the end of the day in the trash dumpster at the end of the subway line. And in the end, they ended up being fined $1 million by the Attorney General for just a bunch of paper in one little Redwell that someone was taking home to do some work on it. So, I mean, and they also faced about 25 individual lawsuits from the folks whose data you had. Now, it was sensitive data, things like HIV positive or pregnancy, those kinds of things, but, you know, that's the kind of data that a lot of schools have.
Yeah, absolutely. If you're a higher ed institution, you have like a healthcare side or you have a research facility or clinics, we've actually seen several breaches involving x-rays, and we're talking about the traditional black and white x-rays, where criminals now are doing social engineering tactics where they're impersonating x-ray disposal companies to come in and actually steal barrels of old black and white x-rays. And the criminals are stealing them not for the PHI that is imaged on these x-rays, but rather you can actually melt old x-rays and extract silver from them. So the silver content is actually valuable to them, and yet, in particular with healthcare entities under HIPAA high-tech, this still results in an investigation. And as to John's point, some medical information actually is viewed very sensitive to Office of Civil Rights, the regulator under high-tech. And if any of that type of diagnosis information is in there, they're going to definitely demand notice is carried out. So things like HIV information, any type of cancer, any kind of reproductive health matter like abortions or pregnancies, and of course mental health issues. Those items to OCR, those are hot buttons. And so any kind of that kind of information that's compromised, you obviously are going to be needing to do some notification. Even disposal of electronic assets. So as you know, everybody wants a new laptop. Every new employee wants a new laptop that's faster and the latest and greatest. So clearly you go through recycling of electronic equipment, not just laptops, but copiers, faxes, scanners. Anything with a hard drive these days, you're going to need to make sure you have a proper practice to wipe them down. Or if you're leasing that equipment, you have it in your contracts that they certify the wipe down and destruction. I don't know if people have heard in the news last month or two, not a higher ed institution, but clearly this could happen to a higher ed, Affinity Health was subjected to a six-figure event because the copier they leased was returned and was passed on to a new customer, which unfortunately happened to be CBS News. And an investigative journalist decided to see what data was on that hard drive, and lo and behold, a six-figure event occurred. So again, think about your electronic assets as you're disposing or returning as part of the end of a lease. You want to have proper wipe down of that equipment. Spear phishing
including
attacks,
the copiers, right?
Yeah, exactly, including the copiers, John. Spear phishing attacks, as we described earlier, where you get those fake emails that look like Bank of America or U.S. Bank and the like. Spear phishing is a little more precise, hence the term, where again a hacker may break into your institution and steal all those email addresses, knowing full well that 100% of those addresses are associated to your institution. So now they can make all of those people receive emails that look like the university, and therefore hopefully have some individuals be gullible enough to succumb to the solicitation. Hacks still occur, network intrusions, there's nothing new here, but of course we need to note they still happen. Lost devices, clearly as you know now, with iPads and iPhones and tablets and laptops, all of these assets can go lost or stolen. Having proper encryption protocols on them is certainly essential these days, and so you obviously want to be mindful that you have the right practices around that. Mishaps due to broken business practices is just a fancy phrase for human error, and a significant percentage of these events are not malicious. They're accidental. They just happen. And again, just demonstrates you can have the best controls in place, the best talent of employees, but an accident is going to happen, and that can still result in a liability event for the institution. And although all of us on the phone have halos above our heads, not everyone does, and so we have to be mindful of the disgruntled employee, the insider. And yes, there's been more than enough examples where certain employees might be enticed by an outside criminal to provide them information on employees or on students. And one of two of the cases I'll talk about fall into that bucket. Next slide, please. If there's one thing you take away from today, take away this. This is some good advice for your IT and IS folks, and even good advice in practice across your risk team. Don't use the B word. The word breach is bad. It actually has legal significance in certain jurisdictions. So we'd like you to educate your teams to call it an incident, especially when you think about when that malware intrusion comes in Saturday night at 10 p.m. and you have the two IT analysts working the graveyard shift, and they may send emails back and forth about, hey, do you see this malware breach going on? That's not good, because at that point in time, more than likely, they haven't copied your in-house counsel for privilege. And lo and behold, you might raise some liability down the road because you haven't really confirmed you had a breach. And maybe down the road you prove, in fact, you prematurely called it a breach, and now you have to defend yourself into justifying why it wasn't. So good practice is avoid that B word. Call it an incident. It certainly just helps you stay a little more defensible as you go through any analysis of an incident that surfaces. Next slide, please. So I'm often asked, Alex, what does a response roadmap look like? How do we begin this process? This is probably the most high-level way I can visualize it for you is in these 4 phases. So that very first phase is what we call the discovery phase. And when you think about the discovery, that's the aha moment where someone or some entity identifies something's gone wrong. This could be an employee coming in tomorrow morning and she tells her manager that her work laptop was stolen from her vehicle last night. It could be the IT department identifying a malware intrusion. It could be the HR employee coming in Monday morning and seeing that the HR office was ransacked and paper records are everywhere. Or it could even be that third-party administrator that you're using, and lo and behold, what they have done is they've had a breach of your data, and now they're telling you about it. And going back to John's points earlier on the state laws of notice, these laws are applicable to the data owner. So even if your third party had the breach, but you own the data, the responsibility of response comes back to you. And so you have to be mindful of getting notices from them as well. And so when that discovery occurs, we go to phase 2, and we have to think about evaluating and investigating. John and I went through a few good examples of the importance of going through an investigation and not jumping to conclusions. This is the really critical phase that, unfortunately, when I see incidents go bad, more often than not, it's usually at a result of organizations either minimizing their efforts on phase 2, or in some cases they bypass phase 2. So you have to really put some effort into investigating. The laws do give you some time before you have to notify, and they do that for a purpose. Use that time constructively to really determine, in fact, if you have an event, and if you do, to accurately define who's been affected. And this is the excellent time to pull in privacy counsel. So John and his firm as a good example, I mean, privacy attorneys, they don't just need to know the law. John and I and anyone else can quickly go and study these 46 state laws and the federal laws. What really makes a privacy counsel stand out, and where John's expertise comes in, is really from his experience in how to manage this crisis. And a breach matter is a crisis. So it's not just the competency in the law, but it's also the competency in this response methodology. And from that investigation, you come to a fork in the road. You either have a breach or you don't. If you don't have a breach, for one, that's a good thing. We call that a non-event, meaning nothing to notify and everyone's happy. But some cases, unfortunately, turn into breaches, and then we have to go to phase 3. And phase 3 is where we deal with the notice obligations under these laws. Do we offer a remedy like credit monitoring, or another remedy that might be more appropriate? Because one of the other big misconceptions is people think credit monitoring is the end-all, be-all remedy to offer every single breach. And that's not the case. You're going to have some events where credit monitoring will not help the individual. You may have an individual where credit monitoring may not help them. Forget the data that was compromised. You may have a minor or a deceased individual or a foreign citizen. Credit monitoring will not be applicable to them. So we have to be thinking about what is the right remedy to include with the notice. There is no laws on the books that require remedy, but in the so-called court of public opinion, you need to consider something. A letter by itself without something or some advice or some means of assisting somebody would not serve well. So you have to think about that. And again, folks like John and the privacy counsels that you would use, they are definitely going to be in line with helping you make those decisions. And then some events, you're going to need public messaging strategy. And there are 3 characteristics that come to my mind when you might need them. One, you have a large breach, and large, relatively speaking to me, is 6 figures or more. 2, you may have a moderate event, maybe 5,000 or 10,000 people. But what if all those 10,000 people make up 80% of a town? Now everybody uses the same grocery store, the same dry cleaner, the same gas station. You know what? Maybe we need to do some strategy of messaging in that area. And third characteristic, regardless of size, you have anybody of notoriety. So you have a politician, a celebrity part of your event. Lo and behold, you might need this. Now, for purposes of discussion here, I put the term public relations here in phase 3. But believe it or not, a PR firm at times may not be the right type of firm or talent to use here. Reason being is PR firms have one purpose in mind. That's to put your institution in the news as much as possible. And let's face it, when you have a breach, you want to be out of the news as much as possible. So there's different types of talent, sometimes called crisis communications or reputational risk advisory firms. Those are the right talents you want to use in this case. Now, once we have letters out the door, we have a call center set up to provide legally acceptable and consistent answers and offering identity restoration. We keep our fingers crossed and we hope that the course of the response is received well by the public, by the people affected, by the regulators. We hope they have a vote of confidence that you've handled it correctly under the guidance of someone like John, and we keep our fingers crossed. And if we do this right, we have a very good chance of minimizing and in some cases eliminating phase 4. But we have to be prepared for it. And so therefore it has to be part of this roadmap. We always have to strive to never have to hit phase 4, but we have to inevitably deal with it because likely it's going to occur. And so that's sort of the high-level methodology you need to think about as you build and construct your plan. And it sort of gives you that roadmap in terms of the guidance of elements you're going to need to consider when one of these incidents surface. Next slide, please. So next slide, please. So one of the examples I can give you just from my past days, here's a college and university. They did a job fair for college seniors, as most do. And lo and behold, they never vetted the vendors that came into the job fair. And unfortunately, 2 criminals impersonated an employer, and they came in, saw an empty table, and laid out a tablecloth, and laid out blank job applications. And in one day, they got 500 seniors to fill out the applications. This was an example clearly where not the right vetting occurred of who's coming into your premise. This, of course, was sort of a little bit of an anomaly, but think about anyone else coming on your premise. Think about the UPS guy or gal or the Xerox guy or gal. Them coming in with a lot of things like boxes on a cart and the like, that's one thing. But what if they're leaving with 6 big boxes? Or the Xerox guy comes in and says, you know, the Xerox machine's busted. I have to haul it out of here. I have to get a new one out of the truck. They're leaving with a lot of stuff as far as I'm concerned. I would actually want to empower my employees to actually challenge them. Imagine if that wasn't the UPS guy hauling those 6 big boxes. Imagine what kind of a breach that would be. It's that kind of awareness you want to try and provide from a vetting perspective of who's leaving your premises with a lot of material. Next slide. This isn't a financial institution, but this is not a higher ed, but a financial institution. But again, this could happen in your location as well. This was a company that had 280,000 investor clients, and they suffered some malware intrusion on their network. And lo and behold, they thought all 280,000 investor clients were affected. So what did they do? They were ready to send letters to everybody. This is sort of in parallel to the case that John brought up. And we actually convinced them not to notify until we reverse engineered the malware to see what was the malware actually intended to do. It was only programmed to look for credit cards that began with the number 3. And if you follow the banking world, those are Amex cards. So we asked this firm, out of those 280,000 clients, which ones of these do you have an Amex card on file somewhere? And that number came down to about 30,000 people. So here again was an organization that was prepared to send notices to every single one of their customers, i.e. bread and butter, and tell them, we don't know what data was compromised, but something was, and we need you to, here's credit monitoring, watch your credit file, and so on. Now they get to notify only about 12% of their bread and butter. They now definitively have determined it's only an Amex card. Their Social Security number's protected. They really don't need credit monitoring. Just watch your Amex card, and if you see fraudulent charges, call in and get a new number. That is a very different message from plan A to plan B. And so it's the importance of that investigation that you want to leverage when these incidents surface. Next slide, please. And I bring this up because, honestly, I think this one takes the cake and really lays out the importance of investigation. This was a hospital that actually wanted to do a disaster drill post 9/11. And they wanted to construct a drill that had mass casualties, but they wanted to add an element of what happens if the network goes out and we have to treat a mass casualty population. So in their infinite wisdom, they had 20 emergency room suites, and they added a crash cart to each of the suites and put a laptop on the crash cart with all 500,000 records of the hospital. And when they went through the drill, at the end of the drill, they went back to retrieve the laptops. Well, they only used 18 of the 20 suites during the drill, so 2 of them were not used. And would you believe it, when they went back to get one of the 2 unused suites, the laptop was missing. They first thought they did not have a problem because they have a policy there to encrypt all laptops. But the IT department had to unfortunately advise them, because of the fact this was a temporary assignment, a temporary drill. Do you know how much time it would take to encrypt 20 laptops, let alone download 500,000 records on 20 laptops? They had to admit they did not encrypt. This hospital held a press conference against advice to tell the world, and we were like, wait, we have to investigate this. And yet they still held the press conference saying there's an ongoing investigation with an unencrypted laptop with all patient records of the hospital. As you quickly can see by reading ahead, 48 hours later, just 2 days later, after looking at surveillance camera video and getting timestamps and looking at log data and getting timestamps of when they were preparing the laptops, we were able to prove that the laptop was stolen before they ever downloaded data on it. So the laptop had 0 records on it. Nothing was lost other than a laptop. So again, the importance here, imagine having now to hold a second press conference. Imagine the reputational harm this hospital faced. This could easily happen at any of your institutions where you jump to that conclusion and the reputational hit to try and renege on the first press conference, it's going to be a huge uphill battle. And unfortunately, this hospital faced a significant reputational hit for nearly 18 months after this event. Next slide, please. So just some education-related events that I've obviously seen in my time. Obviously, one of them that we've seen on a few occasions, I call it the alumni magazine breach. We have seen on a few instances where higher ed institutions are publishing the alumni newsletter or the alumni magazine, and in the production of that one issue, someone accidentally included the Social Security number field on the mailing label. So lo and behold, out in the public, being mailed out was a mailing label on the alumni newsletter magazine with your name and address, but also had your Social Security number on the field. So we've actually seen this happen on, I think I've seen it now 3 times during my past years. Something like this, as trivial, could obviously result in a data breach. We call Google search breaches. Unfortunately, and fair disclosure to Google has nothing to do with Google. We have seen where research and clinics, facilities of hospitals and research teaching hospitals, where lo and behold, a researcher has put data that has not been properly redacted or anonymized, and they put it on a server that's on one side of the firewall that is available for Google to go and search and index for their Google searches. And lo and behold, we come to find out about these events when one lone patient decided at home one night to Google their name and lo and behold found this database sitting there with all their information. We have seen this on several occasions on the higher ed front. We actually had a case of a financial aid office breach where a financial aid office was going through the process of shredding old documents. And they had it set up in the basement of the administration building. And of course, they didn't have a big shredder. So they had the typical, like the kind you can buy at the at Staples or Home Depot or Office Depot. And they hired 2 work-study students to go downstairs and take all these documents and start shredding them. Well, guess what happened? These 2 students started to get a little bored and started to look at what they were shredding, and they're realizing they had a lot of information on students and parents' financial information like tax returns. And what they were doing is every one they were shredding, they were keeping one. Every one they were shredding, they were putting one in their knapsack. And they were taking the dependents' names and Social Security numbers to actually do tax fraud and get tax refunds. And lo and behold, it came to be known when all of a sudden a lot of parents were filing their returns and their dependents were getting flagged by the system at the IRS saying someone's already claimed this identity. So lo and behold, again, an example of a rogue employee per se, work-study students that have caused this. We've seen issues where Office of Admissions had a lost backup tape involving applicants to the university, not actual students, but later wound up being just the applicants that were not granted admission. Lo and behold, you can have archived data like that lost, and it may not even be the students that you actually have. It could actually just be applicants. So again, be mindful of that archived or old data, even beyond your student body or your employee body. And then without a doubt, when you think about K through 12 related breaches, if they happen, there's a lot of unique considerations that you have to take into account because of the population mostly being minors. The notification letters have to be worded differently. They usually have to be addressed to the parent or guardian. There's going to be certain content you may want to include in there that it's unique because it's a minor. And even the remedy you offer. As I said earlier, minors cannot get credit monitoring. So you have to look at identity monitoring or what's sometimes called minor monitoring services by some of the bureaus, the credit bureaus, that can actually still monitor if a minor's Social Security number has been granted credit cards or a loan or a cell phone account. So those are types of things you have to be mindful of that are going to be unique when you're dealing with a minor population. Next slide. So from here, we sort of now talk a little bit about Beazley and the insurance form that we have, which is called Beazley Breach Response, or BBR. What makes it different than what we've seen within the market? Primarily, the biggest difference really comes down to the services end. This is an insurance product that is not just focused on funds that are available for actual claims that come in resulting from, let's say, lawsuits or regulatory fines or penalties or defense costs. But actually, as you can see from what John and I have talked about, there's a significant expenditure and need for expertise before anyone files a claim against you. You're going to need John and a privacy counsel. You're going to need forensics in some instances. You need someone to produce 1 million letters and do a call center for 1 million callers and offer credit monitoring 1 million times over. Beazley actually has a dedicated team within Beazley that is not part of claims that helps you do this. They become that first responder or first contact that then pulls in the experts like John, the experts like forensics, and help you then be able to effectively manage this following that methodology I showed you earlier in that 4-phased approach. The vendors that we provide under the policy, when I say they're vetted, that's an understatement. We don't go just by cost in many cases. In all cases, it's really based off of expertise. As I mentioned earlier, John will likely agree with me. Anyone can sit and research and learn these 46 state laws and the federal laws. What really makes John and the privacy attorney stand out is their expertise in managing these events, because they're multitasked. There's a lot of wheels churning. There's a lot of moving parts. You need someone that knows how to orchestrate all that effectively. And then also the services are there when you think you have an event. So as I said earlier, it's not for you to pull in and notice in and get your carrier on notice after you've resorted all of the investigation work yourself. This is the time to bring in someone like John or a forensics firm to help you stay defensible even as you go through that investigation. And that's probably one of the more significant errors we often see, is organizations are usually try to be left to their own devices to try and resolve or investigate, and then come to us later saying, oh, now we spent a month investigating, here's our findings. And we come to find out that in the course of that month, they really created a lot of other liability pitfalls that they likely could have avoided if they brought in the experts sooner. The policy gets triggered with one email or phone call. Once you do that, it's enough to just trigger and begin all of these moving parts, if you will. And of course, the targeted industries, it goes back to what I said earlier, data owners. Because under these laws, the legal response obligation falls on the data owner, not the processor. So if you have third parties that cause the event, you're still covered as the insured, but again, you as the data owner have that legal obligation to respond. Next slide. And so just some of the differences, again, remember this is a claims handling service with the experts available to you. It's from end to end. Some organizations leave you the freedom to manage your own event. Again, some people feel that they interpret that freedom to be a positive. But again, this is where you have a crisis matter and you need those experts to be brought in. So I almost think of this into an extreme level, and I apologize for it, to think of kidnap and ransom insurance, so K&R coverage. I would almost bet no one on this phone call has a full-time hostage negotiator on staff. You probably don't for a reason. You pull in that expert because you're dealing with a very unique crisis matter. This is no different, just on a lesser extreme. You have a very unique crisis matter that you want to pull in those experts that are available to you to help you here. This is not an opportunity for you to have the so-called freedom to manage the event yourself. And then separate limits for response and liability. So the way this product is structured, you actually have two separate insuring agreements in one. So think of it as two insurance policies in one. You have the third-party liability, which is your tower of funds. Those funds are usually anywhere from $1 to $10 million. And those funds are left for what we call true claims. It's for when you do get sued, when you do have a regulator demanding information or investigating, and you want defense counsel, or you have fines or penalties resulting from the investigation. That's what that $1 to $10 million is for. The second insuring agreement is all these services we've been talking about. So it's everything from John to forensics to notification to credit monitoring to call center. All of that is separate. So in other words, you have, let's say, a $5 million policy. That $5 million is never touched. Not one penny comes out of that to cover John, to cover forensics, to cover notification, and so on. Most of the policies out there actually share that limit for both the response services and the liability. So in those policies, that $5 million start to erode to cover those service costs. And Beazley actually, as I said earlier, we keep it separate because it truly means you're going to leave that tower intact for what we call true claims. The services to be used, it's not the policy you just keep on the shelf for catastrophic needs. You'll find that the deductibles or the retentions are relatively low. A good example, like John Mullen, his retention for his services on our policy is just $5,000. So that's a very, very relatively low and attractive deductible in order to gain that kind of expertise early on in the process. And we do focus, as I said, in certain verticals. Clearly, higher education being a clear data owner would be a clear industry vertical that we would focus on here. And again, the appetite Beazley has had is anywhere from like $10 million up to $5 billion in revenue. Again, it's definitely a market that we are clearly have a strong appetite for and would be obviously a viable market if you fit within that revenue band. Next slide. Just a quick visual, again, just to show you that breakdown I described earlier. Think of it as two separate insuring agreements or policies in one. So we do have the traditional network data liability coverage for claims, but then the response services is what makes it very unique. And all those response services are managed by a response team, as I said earlier, separate from claims, but they're all full-time Beazley employees. They're all in-house. By trade, they're all privacy attorneys themselves. But since Beazley, as a carrier, we can't give professional legal advice, we can at least give that early on indication of what are those recommended next steps. And more often than not, you're going to find that one of those common next steps is pulling someone like John in who can be formally retained by you to represent you in the course of your investigation. Next slide, please. And so just some of the things that we often hear clients say, they think they don't have the exposure. They feel that their IT department, their CISO or CIO has convinced or confirmed to risk that they have the best controls in place. They don't have this risk. Some organizations don't know how to separate hype from what's real. And some organizations feel that this coverage is very expensive. It's not really going to help them respond, but just deal with lawsuits. And again, it's important to know these are all somewhat things that we have to address and make sure are accurate and cleared up, because you definitely are going to still see exposure. And even if IT says that everything is locked down, all I can say is think about your third parties and think about paper-based breaches. These are completely out of the control of the IT and IS professionals. And so therefore that risk exposure is still there regardless. And that's to assume, and no disrespect to your IS and IT folks, that they have everything completely locked down. I'm a technologist by trade and by my background. I can assure you there is no system out there that is 100% effective at preventing a data breach. So you have to still recognize the risk exposure is still there. Next slide. And so some of the challenges some of higher ed institutions or clients or companies may address and bring to the table. Some do not fully understand the difference from a data owner and a data processor. And it's important to know, again, as a data owner, you have full legal responsibility to respond. So you can have a breach that is caused by your third party, by an administrator, a processor of data that you've outsourced. They can have the event, but at the end of the day, you have the responsibility to respond as the data owner. We also have challenges about to the points that John and I mentioned earlier on regulations, thinking, well, we're only in one state. Why do I care about the 45 other state laws? As we said earlier, you have to recognize that the laws are drafted based off of the domicile of the person affected. So therefore, the laws do apply. And if you are in any way an entity with a healthcare side that might be a covered entity under HIPAA High-Tech, well, HIPAA High-Tech provides enforcement authority to all attorneys general. So if you don't want to comply with Massachusetts AG Martha Coakley and her state notice law because you have a strong opinion that she doesn't have jurisdictional authority for that state law, but you're a covered entity under High-Tech, she can come back and enforce and investigate and penalize you thanks to HIPAA. So again, it's a little bit of a diplomatic dance. That's where, again, John's expertise comes to play, because he's going to know where these laws and these obligations apply to make sure you stay defensible. And then internal resources. More often than not, and no disrespect if any IT and IS professionals are on our call today, but more often than not, you're going to have some resistance from them where they think they view this as a slight against their capabilities, their competencies. They feel somewhat offended that you're bringing in insurance because you don't think they can do their job. Again, think of the possibility of breaches that are paper-based or third-party related. It has nothing to do with their competencies or capabilities. The exposure is still there, and we hope that you can recognize that beyond what IT and IS thinks. And then we want you to focus on realistic scenarios. So if you've noticed, John and I did not sit here and present the 4 million person breaches, the 3 million person breaches that have 30 attorneys general investigating. Those happen, but let's bring it out of the stratosphere. I gave you a 500 person example. I gave you a 30,000 person example. That's what's happening day in, day out. It's not all about the multi-million person events. These little ones can just raise the liability stakes just as easy as the multi-million ones. And so we need, hopefully as an appreciation, you recognize that that's where the risk exposure still sits as well. Next slide. And so just some quick facts on Beazley and the BBR policies, what we have today. Right now we have a little over 5,000 policies in force. We have been offering Beazley breach response, or what we call BBR, since October of 2009. So we're now entering our 5th year, and we have had literally double year-over-year growth. We've had 100% growth consistently on this type of policy. Last year, as I said, we had about 321 breaches. The first half of this year, we've nearly had 300. And one thing we're very proud of, out of all the breaches we have had, of organizations that have gone through the response services of Beazley, nearly 100%, I think it's only been 2 accounts, and mostly due to M&A activity, that have not renewed with us. So that speaks volumes in 2 ways. It speaks volumes that the insured really felt satisfied by how we supported their investigation efforts. But more importantly, it even demonstrates that the underwriters still kept those insureds on risk, that we felt confident that they had the right controls in place, they still did the right thing. It wasn't that the underwriter saw a breach and ran away the next year. So that actually speaks on both accounts, and we're actually quite proud of that statistic. You'll notice from a sales cycle, nowadays it's a lot far shorter sales cycle. It's usually less than 12 months. If we were having this conversation 2, 3, 4 years ago, it'd still be a multi-year type cycle. Many of the buyers are still first-time buyers. If you think about, out of all the industries, the one industry that is like really, really heightened to this kind of insurance is healthcare. And even amongst healthcare industries, across all insurance companies, not just Beazley, the penetration rate is still less than 25%. So less than 1 in 4 healthcare entities are buying this. All other industries, including higher ed, is even less. But the risk is still there. It's just a matter of education through these types of programs we're doing with Wright Insurance to have you appreciate really what kind of risk exposure is there and get some of the myths and some of the misconceptions out of the way so you as a risk manager can truly appreciate what kind of risk exposure you have. And so with that, with just a few minutes left before we hit 12 noon Eastern time, again, I thank you so much for your time, and obviously if any questions come up, we'll be happy to entertain them.
Okay, thank you so much, Alex. We actually do have some questions from a bunch of people, so maybe you can help answer them.
Sure.
So we have one from Jeremy, and he says, you mentioned credit monitoring was approximately $20 per head per year on average. What do you see as the total average cost per head for credit monitoring, call centers, the notification costs, et cetera?
Yeah, so what I try and do, and I provide you retail costs, because clearly once you work with a carrier, the costs are going to be considerably less in-house. So what I call consumer-facing services are notification letters, call center, credit monitoring, and identity restoration. And if you think of those 4 services, cost per head, and already accounting for the percentage uptake of credit monitoring, because not 100% of the people uptake it, I would use a fair figure of like $10 to $15 per head on a retail side. On the carrier side, that number is going to be less, but even more importantly, with Beazley Breach Response, those 4 consumer-facing services are not provided to you in the policy on a dollar basis, but on a quantitative basis. So you as an insured, you really don't even need to worry about what that cost per head is, because you're never going to be subjected to a dollar amount. Your policy may actually say you have a $5 million tower for third party, but you have 2 million notified individual allowance in your policy. That means you can have a breach, you can have breaches up to 2 million people for that year, and whatever it costs Beazley to notify, to have a call center, to do credit monitoring, to offer identity restoration for those 2 million, you as the insured, you never have to worry about the cost.
Okay, we also have one from Jonathan, and he wants to know, can you address the risk from omnibus around the new healthcare laws?
The risk around it, the biggest risk I see so far from the omnibus final rule is now that it's been a big game changer where before you were innocent until proven guilty, now you're guilty until proven innocent. So you have now a presumption of guilt or a presumption of a breach, and it's your job as a covered entity to now prove that you've had a low probability of risk. So under the final rule, before the final rule came out, we had this risk of harm analysis where you had to demonstrate financial, reputational, or other harm and the like. That pretty much has gone out the door now, and it's like you now have you've had an incident, you now have a breach. Prove to OCR that you don't. Prove low probability. And so far, the early initial guidance that OCR has provided is they've given us this so-called 4-factor test, really these 4 considerations to help you determine if you have low probability. But that means you're going to have a higher frequency, in my opinion, of folks like John. You're going to need a higher frequency of forensics investigations, because unless you plan to just notify, you want to prove otherwise, you have to invest in privacy counsel and forensics to do that. John, I don't know if you have some thoughts there of what you view as additional risk now with the final rule.
This is Ryan. I'm an attorney who works with John. He had to step away, but I think you summarized fairly completely many of the risks we've seen our clients face with recent breaches.
Oh, okay, great.
Alex, also Jeremy is just responding to the last question we were talking about the cost. Yes. And he was saying, I'm looking at it as a marketing point to insureds. If they had to pay themselves for the cost per record, how much typically would that be?
If they did, like I said, on the retail basis, what I see out there from just the prevailing markets, like $10 to $15 per head is what I've been typically seeing out there. So for like an uninsured entity that had to go to a facilitator, there's a lot of firms that do response services for breaches. Generally speaking, and this is obviously very broad, but generally it's like $10 to $15 per head is what it's going to wind up being. Now, I have seen some facilitators charge a lot more, but what I would call reasonable would probably be around the $10, $15 per head rate.
Okay. We also have a question from Karen. She wants to know, there are obvious different forms of cyber crimes. How successful is encryption in the fight to protect computer users?
So encryption, in my opinion, is something you absolutely essentially need to consider. Because if you look at breaches that have occurred that involve a backup tape, a lost or stolen laptop, a thumb drive, smartphone, tablet, I'm just rattling off whatever I can think of right off the bat. If those devices were encrypted, for one, you have a safe harbor in virtually every jurisdiction. The only jurisdiction that I know where you might come to some challenge even with encryption is Massachusetts. But beyond that, that's usually the safe harbor. And particularly if you have anyone on the phone that is a covered entity under high tech, OCR has, their investigators, their regional investigators have said it time and time and time again, encrypt, encrypt, encrypt. If you encrypt, you can avoid a lot of these headaches. So I can't stress enough the importance of having encryption in place, because it really can save you quite a bit of effort of investigating work, as well as actually dealing with an actual breach. Now, you still may have encryption in place, but that does not absolve you from that investigation phase. So make no mistake, I'm not stating that because you have encryption, you can skip phase 2 in that roadmap I gave you, because there's been more than enough occasions to prove that, as Murphy's Law says, the one lone laptop that never got encryption was the one that was stolen, even though you have an encryption policy. Or I had a good example, in fact, a few months ago, where we had a breach involving an employee who was at a Starbucks, and he was at a Starbucks, went up to pick up his coffee, turned around, his laptop was stolen. And the insured contacted us saying, oh, just want to put notice, we had a laptop stolen, but we have encryption, we're good, right? And we're like, well, let me ask you a few more questions. Where did it occur? Oh, the employee was at a Starbucks, and they went to pick up their coffee and came back, and the laptop was stolen. Okay, was the laptop on? Well, yeah, he was working on it. Well, if he was on and working on it, that means he was already past credentialing of the encryption. So in effect, it was almost like the laptop was unencrypted. So just a very simple example that don't just assume because you have an encryption policy that everything was indeed encrypted when the theft or the loss occurred. You have to still investigate to determine if in fact that is a reportable event.
Okay. We also have one other question from Suzanne. What does your organization do to develop an effect risk management tool for your clients to minimize incidents?
Yes. So one of the things that this policy, Beazley Breach Response, if you were a client was to be insured under it, we do offer a risk management client portal that has a multitude of resources on it for our insureds. And one of the things we offer in there are sample incident response plan templates and response plan workflow diagrams. And one of the things you really do need to consider is to have an incident response plan. Because when you have a breach or a potential breach incident, not having a roadmap in front of you for the team, the response team to use, you're going to create more liability. And John made reference earlier to the Poneman study. There's an actual metric that Poneman did a survey on about the risk or costs associated to organizations that had written plans versus those that didn't. And the costs for those that didn't were higher. When you have a game plan written down and it's reviewed and it's tested once a year, it actually serves you better in terms of the cost exposure and risk exposure if you were to have an incident. In fact, many laws require it. So if you're HIPAA high-tech, if you are a covered entity under the Red Flags Rule Amendment, if you're a creditor and you apply the Red Flags Rule Amendment from FACTA, if John made mention of Massachusetts 201, the information security law there, MA 201 and I think 13 other state information security laws mandate you have a written data breach response plan. So having it is not only going to be required under many laws, but it will definitely serve you well in reducing your risk exposure.
Okay, great. Does anyone have anything else they want to ask before we go? I'm just going to check the chat. I don't see anything. Okay. Thank you guys so much for coming. We really appreciate. Oh, actually we do, from Karen. Can you give insight on security laws for the state of New York?
Yeah, so New York State, of course, has a notification law. If you exceed a certain number of individuals, and forgive me because I just don't have the law in front of me, you would, of course, need to notify the Attorney General. They also have two state agencies, the Department of Consumer Affairs, and I think there's the equivalent of some kind of Department of Cybersecurity or of some sort, and I'm not stating that accurately, that you would also have to notify in the event of an incident. So New York State itself has those. New York State has, I guess, what I would call very typical out of the 46 state laws. There's not too much that would stand out as unique there. But again, each of the states are going to vary from state to state. You still would have to necessarily look at what each of those state requirements are.
They want to know, can they get a copy or access to the risk assessment tool for their risk management team to review?
Well, the tools that we have, as well as like our response plan templates and our training materials that we have, those are available to our policyholders. So unfortunately, it's not something I can just share out to the general public. Once you become a policyholder, you then get access to these resources. Because I apologize for the shameful plug, but I mean, Beazley's not in the just the business of covering insurance, covering risk for our insureds, but we're very heavy on the services and the risk management end. So a lot of what we do is also upfront. So once you buy a policy from Beazley, it's not just the policy sits on the shelf. You will have access to a lot of risk management services and experts that are at your disposal. Quite frankly, my role here at Beazley, along with several other members of the response services group, our job is to do what we call client outreach. It's my responsibility to take calls from our insureds when they have such questions, when they want some guidance on a particular matter or on a particular issue. That's what Beazley has. We have a team that just does that, what we call client outreach. So as much as I'd love to share this material out with the folks here on the phone, we do keep it for our policyholders.
Understandable. So I want to thank Alex and John for coming today and speaking to us. I think it was a great webinar, very insightful, a lot of great information. I want to thank all our attendees for coming, taking the time out of your busy schedules to sit down with us and have this discussion. The contact information you see on the slide right now, that is for Adriana Melitez. She works with Wright Specialty. She will be quoting for Beazley. If you are interested in this policy, if you have any questions regarding policy or any questions about the program itself, you can contact Adriana. She'll be more than happy to help you. Obviously, I also know that a lot of you work with Reggie or Jeff. If you feel more comfortable, you can always reach out to them as well. But Adriana's here to quote in-house and be very dedicated, her email information. If you need anything that you saw today, the slides, if you didn't download it when you first came into the webinar, just shoot us an email and we will make sure that you get one. We will also send it out to everyone as well. That was on the registration. We'll also be sending out, we recorded this webinar. So if there's anyone that you know that wanted to attend but didn't have time, it will be on our website on the Wright Insurance Group landing page under the videos and podcast section. And it will also be sent out as well, the links. We'll send out the links along with the slideshow. So thanks, everyone.